Welcome, everyone. We're so glad that you're here, and we will begin our first contract clarity webinar shortly. Thank you, everyone, for joining this contract webinar for the Dance Workforce Resilience Fund. My name is Ritika Ashok. I am the grant-making assistant at Dance.NYC. I am a tan, brown-skinned Indian American woman with big brown eyes and long straight black hair that is on front of me right now. I'm wearing a black t-shirt and I am in front of a light blurred background. Before we begin, we would like to say thank you to our accessibility service providers. ASL interpretation for this webinar is being provided by Michael Barrios and Kat Dunhams on behalf of Sign Nexus. Closed captioning is being provided by the Viscardi Center. Thank you both for being here. We will also drop a link to the stream text link, which are the captions that can now be found in the chat. If you would like to pin our ASL interpreter, you can click on the dots in the top right corner of your video screen to pin. Also, please note that this webinar is being recorded. The webinar recording, the slides, and the transcript will all be made available on the Get Help page of Dance.NYC's website on the main DWR Fund page. I will now pass on to Sarah Rower, Dance.NYC's interim ED, to walk us through a land acknowledgement.
Thank you, Rithika. As Rithika mentioned, I'm Sarah Rohr. I am currently the interim executive director at Dance.NYC. I identify as a non-disabled, cisgender, white, queer femme. I have pale skin, short, curly, salt and pepper hair styled in a mullet with a magenta streak through the curls over my forehead. I'm wearing a dress that appears like a V-neck at the top and is floral patterned with magenta, purple, bright blue, navy, and green. I'm adorned with a gold snake pendant and tiny boulder opal necklace, each of which is a gift from someone I cherish. Behind me is my living room in Lenapehoking with a much debated robin's egg blue accent wall in view containing 2 large windows. I'll lead us into our land acknowledgement next. Dance.NYC would like to recognize our country's history and its legacy in the space we occupy. Parts of this acknowledgement have been adapted with the guidance of Indigenous dance artist and activist Emily Johnson, who worked on Dance.NYC's land acknowledgement with us. It is iterative and may undergo revisions regarding the Ramapo people in the near future as we learn from an expanding community of Indigenous artists. I would like to acknowledge that the City of New York is on stolen land. More specifically, Lenapehoking, the unceded homeland of the Lenape people, who are also recognized federally in the United States as the Delaware Nation of Oklahoma in Anadarko, Oklahoma, the Delaware Tribe of Indians in Bartlesville, Oklahoma, the Stockbridge Munsee Community in Bowler, Wisconsin, and in Canada as the Munsee Delaware Nation, the Moravian of the Thames First Nation, and Delaware of Six Nations. We recognize that as an organization based in NYC, we have benefited and continue to benefit from the systemic displacement and subsequent erasure of Lenape people and governance on their land. Please join me in taking a moment to recognize and reflect on the centuries of violence, displacement, forced migration, and settlement here, as well as the centuries of resilience and leadership of all Indigenous and First Nation peoples on Turtle Island that have led to our livelihoods in New York City today. You can begin by joining Dance.NYC in supporting Lene Lenape Axquihoc, which is a group of Lenape matriarchs from 5 of the federally recognized Lenape tribes who are working to increase Lenape presence in Lenape land both immediately and in the long term. Even if you can't donate at this time, I urge you to bookmark this site as it's both stunningly beautiful and contains a plethora of wonderful educational resources. Please join me now in taking a moment of silence to integrate and enliven this information in our bodies. Thank you. A few more guidelines as we get into it. Please mute yourself if you're calling in. We have muted all participants to start. And please submit questions as they occur to you, but using the chat feature. And we'll get to as many as we can at the end during a Q&A session. When you do submit questions, and use the chat to everyone feature so that everyone else can see the questions being generated and avoid any duplication of those questions. Every question will be saved so that if we can't get to them, we can address them later in follow-up or in our FAQs. Consider asking questions that may apply to additional potential applicants, keeping in mind that we do have one-on-one legal assistance and a direct email address available for any hyper-specific inquiries. We don't recommend the raise your hand feature during the webinar because we're unlikely to be able to pause the presentation prior to the Q&A section. And with that, we'll get into it, and I'll pass it on to Janae Williams, our DWR Fund legal consultant, who will lead us through a contract webinar presentation. Take it away, Janae.
Thank you. It's so great to be here with all of you today. So thank you so much to everyone who has participated, everyone who's put together this workshop, and just everyone at Dance.NYC. It's been an honor to work with you over this time. And just in the interest of being consistent, I am a Black woman. I identify as queer, and I have long Black locks. I have on a Black blazer, and in true New York fashion, a red lip as well. And I'm also on a white background wall. So just to start this presentation off, I have to read you the disclaimer just for continuity purposes. So this workshop is for informational purposes only. J. Williams Law PC, which is my firm, assumes no liability for the use or interpretation of any of the information contained in this workshop. This workshop does not establish an attorney-client relationship and should not be an alternative to obtaining legal advice from a licensed attorney based on the specific facts of your legal matter. Next slide. So today, with the agenda, we're going to speak about a little bit about who I am, because I know you all don't know me yet. I'm going to share your rights as an independent contractor. We're going to go through the independent contractors agreement that was worked on through Dance.NYC by me, and also will be supplied to you as a resource. Then we're going to also have an opportunity for a Q&A, and then follow up with what your next steps will be with Dance.NYC. Next slide. Okay, so who am I? I am an attorney and business advisor for business owners and public figures. I started my firm back in 2012, and I started advising artists and musicians and creative individuals starting in 2013. And I've now coached people from all over the world on the foundations of business. And I've also, as an attorney, negotiated deals and docuseries, negotiated deals for films and docuseries and television shows, which have premiered on HBO, Netflix, E-Network, HGTV, Amazon Prime, South by Southwest, PBS, and Hulu. And personally, I am also a former musician, which is why I worked with musicians for so long. And I am also a playwright, and I have written and produced 2 plays. Next slide. Now that you know a little bit about me, we can get into why you're here. So we're first going to talk about some of the rights that you have as working in NYC as a dancer, and what are a few of the laws that have been in place to actually help you navigate the legal system as you are getting jobs and working within the industry. Then I'll also share a little bit about what's the difference between an independent contractor and versus an employee. So, no, go back. Okay, thank you. So, with New York City salary transparency law, I have the reference here in case you want to look it up yourself, for New York. But this particular law was put in place so that when you go to, or when you are applying for different jobs, there is transparency around what those jobs actually pay. So as that relates to you as a dancer, it's great because you are more often than not going on auditions, and in this industry it's not always known what the pay is going to be initially. And so New York City has done their best to institute a law that will allow transparency on what the on job postings, so that you know how much you will be paid before you go to an audition. And so that's really good for navigating when you're going for jobs and trying to figure out what jobs you're going to have. So if there isn't a listing for your pay on that job, then number one, you can skip over it because salary transparency. But number two, that isn't necessarily in alignment with the law in New York City. The other law that is in place to help with freelancers is a act called the Freelance Isn't Free Act. If you are a freelancer or an independent contractor, you probably know about this law. It was created and instituted in 2017. And it basically states that you are entitled to timely payment for all of your completed work, which means within 30 days of your completed work. You are also free from retaliation. In the dance industry, that is often a concern because if you do try to assert your rights or assert the responsibilities of the contracting party to pay you, oftentimes people are nervous about doing that because they don't want to be blacklisted from the industry or named as being difficult. We're going to speak more about that when we get into the contract. But just know that actually in New York City law, the contracting party cannot retaliate against you for asserting your rights. You also have the right to file a complaint in the event that they do try to retaliate or you aren't paid properly. Just note that also all jobs that are over $800 must be in writing. So if you are applying for a job as an independent contractor to work with a company, if it's over $800 within a 120-day period, that contract needs to be in writing, which is why Dance.NYC is supplying you with a contract that you can utilize in these instances. And as far as filing a complaint, you can file that complaint with the Department of Consumer and Worker Protection in the event that you feel as though you are being discriminated against or you aren't paid on time. And if that is the case, and the contracting party has 30 days to respond. If they do not respond to your complaint, you have the right to take them to court. If they don't show up, then there will be a default judgment entered on your behalf. And then you will be able to move forward with getting paid or whatever the wrongdoings or issues are within your case. Next slide. Okay, so thank you. So we can switch gears and speak a little bit about independent contractors versus employees. In the dance industry, oftentimes you are going to be considered an employee when it comes to larger productions. Let's just say, for example, something on Broadway. There are also independent contractors, but there are distinct differences between one or the other. So some of the considerations to determine your status as an independent contractor are the following. You have freedom from direct supervision, control, and the performance of your duties. So for example, if you were to perform remotely and you needed to submit a dance recording, you can do that independently, submit it, and then be paid. You also have, if you have a business and you offer your services to the public, you either can set or negotiate your own rate. You have the freedom to refuse offers, pay your own expenses, and you're free to work with other people outside of your status with whomever is hiring you. This is not the entire list of what constitutes being an independent contractor versus an employee. However, these are some of the things that you may consider when you're trying to figure out, does independent contractor status or employee status apply to you? Next slide. Okay, so now we're going to go straight to reviewing the agreement so that you know a little bit more about the agreement that you've been supplied with from Dance.NYC, and we will take some time to answer any questions that you have after we review that agreement. So this is the independent contractor agreement template that Dance.NYC is supplying you that you can utilize when you go for different jobs within the dance industry, and utilize this contract as an anchor to legally assert your rights, get paid, know the conditions of your employment and arrangements, etc. Okay. This agreement is meant to be a binding contract, and it's crafted to ensure that you have the protection that you need in your relationship with these other companies. So I would caution against you changing this contract by adding other clauses in it. There are areas where you can remove certain portions of the contract, and I do notate that in the document that explains this contract. Now, to be clear, you will also have a document that explains each section of this contract in detail. So yes, take notes. However, know that you will also have an accompanying visual document that explains both of these sections. I just want to go through it with you in the event that you have questions and to provide more context, okay? So let's start. This section here is highlighted because there are two sets of parties that will be added to this agreement. It will be the organization, contractee person that is hiring you. You will enter in their information, meaning their name, and then you will also enter in their business address. They will be referred to through the contract as the contractee, and your name as the dancer or the party that's being hired, and then your address here, and you will be referred to through the document as contractor. This section basically states the engagement that you're interested in creating, like the intention of the contract. And then we get into this section, duties, and I'll speak more about this this section. So when it comes to what your position will be, you will add your position in the role that you're being hired for, and the production that you're being hired for, and list here the requirements or responsibilities that you have as you're working with this particular party. So for example, if they require that you attend rehearsals or arrive in a certain attire, make sure that that's added into this section. And then this section, which is the location, this is the location of where the full production will take place. This is not where you will be rehearsing. So let's just say if there was an off-Broadway production that was, at a local venue, you would add the location here. Now, if it's remote, meaning they're asking you to perform, record yourself, and then post it or send it to them, then you would not have this section. You would remove this section here, and then you would just have this section. However, it's the other way around. If there is a location, then you would remove this section here. But you will be performing any services that you have at either this location or this one. Then we move down to the section where you will add the dates. So this area is the dates of the performances, if there are any. And then in this section, you will add the proposed schedule for your rehearsal dates. This is something that you should confirm with them prior to signing the contract, prior to accepting the job. Know what your performance schedule is. And as a contractor, you are entitled to have breaks. In this contract, you can determine and agree to what the contract, you can agree to what the rehearsal times, proposed schedule, and the breaks will be. If you need additional breaks or you need to be able to control the breaks that you have, that's what this section is for, to add it here. And any of these changes to this section must be agreed on by you both. So if you have a schedule here and then they decide to change the schedule in any way where there are more rehearsals added, for example, that must be mutually agreed upon by you both. They can't do that unilaterally without informing you. Okay. So that's section. I hope that makes sense. Then we move to working hours and conditions. So in this section, we wanted to make sure that you had an opportunity to add in how many proposed hours will be required of rehearsal. Now, this also has an area that says not to exceed a certain amount. The reason why I added that was I wanted to make sure that you had an opportunity to require notation of how many hours you will need or you will be required to be in rehearsal in order to get paid, and that they won't add so many rehearsals to the schedule that you can't fulfill your obligation and now your payment is in jeopardy. So not to exceed X amount of hours, and the total hours of your performance time is also added in this section. So you have the proposed hours for your rehearsal, and you also have the proposed hours for your performance. You are also, as a dancer, you are entitled to have adequate working conditions. So I added in air conditioning or a heated rehearsal space, accessibility. You can also add if there are other conditions that you need in order to carry out your duties as a contractor in this performance. You can add those here, but you should be able to have conditions for your performance that will allow you to perform your best and to fulfill your obligations within the agreement. And you can speak to them about what those working conditions are prior to actually signing the contract and add those into this section. So section 4 speaks of the term of engagement. So this is the portion of the contract that speaks to when your engagement starts with whomever is hiring you. So once you sign this contract and they sign the contract, you're now in a binding agreement that you are going to perform services and they're going to pay you. And this agreement can only be extended outside of the proposed working schedule and the proposed times and dates unless you both agree. And unless you voluntarily or involuntarily or voluntarily terminate this agreement, meaning like if you decide that you don't want to work with them or they decide that they no longer need you, then this agreement can be terminated. It has to be a mutual agreement for you to extend it, but it doesn't have to be a mutual agreement for you to terminate the contract. for you to decide that you no longer want to work with this company. You have the freedom to leave. What you can expect if you decide to leave or not is that you will be compensated through the amount of time that you've actually worked with this performance. So whatever you agreed to, as far as if we go into the section of compensation, whatever you agreed to here as far as your compensation, you will then be able to receive payment for your completed work. So if you've attended a certain amount of rehearsals or performances, and then you decide to terminate the agreement, or they decide to terminate it with you, they are entitled, you are entitled to be paid for the time that you did work, not any time after that, but any time before that, if that makes sense. So as full compensation for these services, you will put your dollar amount in currency here. So in this section, this is where you will add what you agreed to be paid or what they told you the payment would be. So if it's not up for negotiation, that you will still add the amount here. If it is up for negotiating and you want to negotiate it, then once you come to an agreement on how much you will be paid for the performances, you'll enter that dollar amount here. This section is very important because it contractually binds them to paying you on whichever schedule you decide. So on this document, you can decide how you're going to be paid or when you're going to be paid. It has to be agreed on, or you will just be entering what they have listed in the posting. So it will be here, and they will be contractually obligated to pay you in that way and on this following schedule. Section 6 will tell them how much you will be paid. Section 6 will tell them how you will be paid. So your method of payment, meaning like if you're getting paid via Zelle or a wire or direct transfer. If you're not getting paid a lump sum, then you can add in here biweekly, monthly, or whichever distribution total and basis that you need. So you'll add that here. Now, the expense section basically outlines, well, here, this is section 7. So this section explains how they will be responsible for paying any of your out-of-pocket expenses for the performance, or if they offer a reimbursement for the performance. During this, like, you should discuss this portion with them before you actually decide to join the performance, and before you sign the contract. So if they offer travel expenses, like to and from the performances, then you will be changing this little portion here. So notwithstanding the foregoing, contractors' traveling expenses to and from the performance location shall be or shall not be reimbursable. So you will change that here. If they do reimburse for expenses, then this section will stay. If it doesn't, if they do not, then you will remove this section. Section 8. This is a section that denotes that you are an independent contractor. They're not responsible for paying your taxes or providing the same benefits that they would an employee. So for example, vacation, sick pay, retirement benefits, workers' compensation, things of that nature. They're not responsible for paying that as an independent contractor. This contract specifically needs to state it so that it can't be misinterpreted that you are an employee, so they have a certain level of control over you, or that you are not a contractor, and so you do not get the same benefits and the same freedoms of an independent contractor. In Section 9, this section is related to your intellectual property rights. So anything that you create for the production, products, sets, choreography, any of those things, that shall remain your intellectual property. So this is a very important currency, and you should have and retain your rights to ownership. So for example, in the event that they require or request you improvise in the performance, and then they intend to use your improvisation in the show as an ongoing part of the show, regardless of whether you're involved, that's your intellectual property. So you may want to speak to them and have like a side conversation about how your intellectual property will be compensated or how it will be utilized inside of the overall performance. Now, this is very different from asking you on any particular night to just do a freestyle dance or something like that. If it's going to remain a part of the show and it's going to be consistent, and it was your genius that created that part of the show, that is your intellectual property. And this section states that that they are not authorized to use your creative works unless you agree to that in writing. So this is something that you should discuss when speaking to them about the show or about the performance, if you are going to be contributing anything to the performance that would be under the guise of intellectual property. And I mentioned some of the examples of that before. And this may not apply if they're not asking you to include anything. And if that's the case, then you can either keep this section or remove this section. Name and likeness. So this section basically states they can utilize your image, your name, any identifying information about you. So your physical appearance, your voice, any distinctive traits that make you identifiable, they can use that in the production, on their playbills, on their marketing materials, etc. You are allowing them to utilize your image for those purposes, but only for those purposes. They are not allowed to take your image, name, and likeness and utilize it outside of this performance or this production without your permission. Okay, so now this section here, section 11, which is the non-disparagement, this section is incredibly important because when you are a dancer and let's just say things go really wrong in the performance and you have issues and you want to leave the performance, you're not being treated well, the working conditions are poor, or a host of different examples of how you're being treated poorly. You have the right to speak about what is factual, and this section protects you from, if you decide to leave this performance, this production, or terminate this contract, you can then move forward without worry that they will disparage your name within the industry. Now, remember, the Freelance Isn't Free Act also protects you against retaliation, but you also have an additional layer of protection under this clause. So in the event that a dispute arises between you and the production, the hiring party, then you agree that you're not going to disparage your name, and they agree that they will not disparage yours. So you both are deciding to walk away without speaking ill of each other. Now, that does not restrict your free speech as you are speaking about what is true. So if you share the working conditions you weren't in alignment with what you were promised, you weren't paid on time, and things like that. You can speak about those things freely because they're factual. What you cannot do under this clause is say, I hate the producer, this show sucks, things like that. And they cannot do the same for you. It is a fair mutual trade that we decide we will part ways, not speak ill of each other, and move forward. This also protects you from social media retaliation. You have a right to work with a performance or a production. And if it doesn't work out, then you move on and they move on, and everyone is okay. So that's why this section exists. Now, section 12, which is indemnification. This section is very important because in the event that the production gets sued by a third party, they are protecting you, if they agree to this clause, from being sued or brought into a lawsuit that you have nothing to do with. So oftentimes dancers forget to have this clause, or they remove this clause from their contracts. I recommend that you do not, because it protects you from any business dealings. You have no idea what's happening on the back end of these shows. You are just performing in them as an independent contractor. So this clause protects you in the event that issues happen with the show, they're sued by a third party, you will not be implicated or brought into a lawsuit that has nothing to do with you. That's why this section exists, and keep it in. Now, section 13 talks about, in the event that you do have a dispute or a controversy or an issue, first step would be to speak to the production and try to negotiate with them to have your issue resolved. If that doesn't happen, then you can submit your issues or your grievances to the proper court that would preside over your issue. That depends on where you're located. So whichever court you will utilize to resolve the issue will be based on where you are located. In the dispute involving unpaid balances by the company, they are going to be responsible for your costs and your attorney's fees, if any. So just know that you will be covered, and your pay will not be utilized for attorney fees and costs. They will be paying those if they are in the wrong and did not pay you. Now, this section 14, the force majeure section, basically this section is utilized for if there is a issue in the world or in your local community or area that has nothing to do with you or with the performance itself, but is a national threat or act of terrorism or interruption to the state in terms of their travel, labor strikes, civil disturbances. These are the kinds of things that would impede on your ability to carry out your obligations in this agreement, or the production may be shut down because of one of these things. That means that you both are relieved of your obligations under this agreement, meaning you do not have to travel through labor strikes in order to get to this performance to perform. If that is something that is going to be disruptive to your work, disruptive to your ability to get there, and it has something to do with the society and what's happening in the world, not with you directly or with the production directly. The only caveat to this section is they are still obligated to pay you through the completion of your work. So they still have to pay you for any work that you've completed. They just are relieved of their obligations to pay you moving forward until the resolution has been made. So think about the pandemic and how it shut everything down. That's what this clause covers here. So here in the termination section, either party can terminate this agreement. We mentioned that earlier. If you're unsatisfied with the work, if you're unsatisfied with the performance, if they are not fulfilling their obligations, you can terminate this agreement. And this section here, this sentence here, allows you to add in the amount that you would be paid through the date that either they terminate the contract or you do. So we added that you can add a prorated rate here of how much you would be paid per day, or you can add a flat rate. And that's the reason why you can change this section. Just make sure that whatever you add here is enough for you in the event that you decide to terminate this contract. The choice of law, it's the state of New York for this contract. However, if you live in a surrounding state like New Jersey, for example, you can add that section here. But remember that if you do have a contract that is in your state and it's not the state of New York, the Freelance Isn't Free Act does not apply because it only applies to the state of New York. So just know that this contract is what's going to carry the relationship. There won't be a separate set of laws that are for New York City that will apply to this contract, but it still will be a viable agreement. It will be what runs and what runs the relationship between you and the hiring party. Section 17 is around the severability of any portion of this contract. So if there's any part of this contract that is held by a judge to be invalid. So let's just say they decide section 15 is invalid. That does not mean the entire contract is invalid. Everything else about the contract will remain intact. So this section is added to contracts because if there is a particular part of the contract that is being challenged, that doesn't mean that the whole contract is invalid. It's still a fair and binding document, even if there's a portion of the document that doesn't apply to the situation that you're in at that moment, if that makes sense. Now, the assignment section, this section speaks of your inability to delegate to someone else. For example, a friend who's a dancer, you can't take your contract and say, okay, this is your contract now, you go on my behalf. Also, if you sign up for a performance or a production, that production can't then say, you know what, we don't need you. We're actually assigning you to a different production. That's not what you agreed to. You agreed to the production that you signed up for, and they agreed to work with you directly. So this section prevents you from assigning this contract to someone else, and it prevents the hiring party from assigning you to a different production that you didn't sign up for. The goal of this contract is to make it as fair on both ends while also protecting you. Section 19, notices. So if you end up needing to take this contract to court. The notice that you will have to provide to the hiring party, whoever is a part of the production, or whichever individual hires you, this is the section that has the instructions for how they are to be notified that there's a claim being brought against them. So that's this section here. And if you have any questions about any of these sections, like I said, you will have a document that explains each section in detail. And I'm also available for you to speak to me farther if you have any questions or any concerns, or you're confused in any way about the contract. Now we're at the final section that states that there's no modifications or changes to this contract without it being signed by you and the other party. So neither of you can change this contract. That protects you because you don't want them to change your pay or the schedule or the working conditions or your intellectual property rights. None of those things can be changed without you and them being able to sign the contract, or sign the change. And then we're at the signatures. So you will be signing here, and then they will sign here, and there you go. Now, we also have a short form version of this contract. So if you do not want to utilize this entire agreement, even though it's around 5 pages or so, if you don't want to use this longer form contract, we also have a short form version that you can send to any party that you're working with, and it's via email. So that particular contract has some of these same clauses inside of it, and you can add in the information that's necessary, and then send that over. And what you need to do once you send it to them is ask them to reply back to that same email and say they agree to what you wrote. And that also creates a binding agreement between you and the hiring party, the party that is hiring you for the production. So you have a short form version, you have a long form version, and you also have a long form version with an explanation for each section. So that's the end of presenting any information about the contract, and we can move to questions.
Hey, hi, Jenny. Thank you so much. That was an amazing overview of the contract. Hi, everyone. I just want to take a quick moment to introduce myself. I'm Anne-Marie Lonsdale, Interim Grant Making Manager with Dance.NYC. I am a white woman with brown hair in a messy half ponytail, wearing a white t-shirt and sitting in front of a teal wall with some art. We are now going to move into the Q&A portion of the webinar. We're going to ask that everyone submits questions to the group using the chat feature. Please consider asking questions that may apply to additional potential applicants, keeping in mind that we also have one-on-one legal assistance and a direct email address available for hyper-specific inquiries. All questions and answers, including those that we might not get to today, will be posted online in the FAQ page, which is going to be shared currently in the chat. So just want to take a moment. Sarah and our team are going to add some questions into the chat, and I'm going to read them out. If I am in Dance.NYC's service area in New Jersey, so I'm eligible for this fund by virtue of my location, what parts of this contract should I be aware of amending because they don't apply in the state of New York versus the state of New Jersey?
It's just the part of the contract where it says which laws um preside over the contract. So you just
Great.
need to change that to New Jersey. Everything else is standard contract language. So there isn't anything that is New York specific. This is US common law specific. So just change the portion that is which laws preside over the contract, or which state presides over the contract.
Right. So like a find and replace of New York to New Jersey would be appropriate.
Correct. So if you go to the, I don't have the contract up, but the section at the very end, hold on, I'll tell you. It was 16. So choice of law. So the laws of the state of New York shall govern the validity of the agreement. That is highlighted in the document in yellow. So it says New York there, you change it to New Jersey and you're good. What I was speaking of earlier was the Freelance Isn't Free Act, which does apply to New Yorkers. It doesn't preside necessarily over this contract. The terms of the contract are binding when with this contract once you sign it and the other party signs it.
Gotcha.
The Freelance Isn't Free Act allows you to be able to file a complaint
Yes.
and in the event that you're not paid. And that's with the powers that be in New York City.
Great. Here's our next question. Could you explain the terms contractor and contractee? Which one am I if I am the dance performer?
So I mentioned that earlier at the very beginning. You are the contractor. So you're the independent contractor. You are presenting the contract to them to sign. They are hiring you, so they're contracting with you. So they would be the contractee. But that is also explained in the explanation document as well. So even if you don't remember it from this presentation, you still have a document that explains that at the top.
Perfect.
Mhm.
Thank you.
Mhm.
On Dance.NYC's website, for the purposes of the DWR Fund, it says applicants must have a fully executed contract. What does that mean in reference to the document that we just went through?
So you have to have a contract that states what you're going to be paid, the terms, etc. You can utilize this document for that purpose, or the short form document for that purpose. For the fund, they just need to know that you have actually been hired for a job. So that's the reason why we're supplying resources to you so that you can utilize those if you need them. If you have some other type of agreement with them, then you should be able to submit that as well to the fund, as long as there's a confirmation that you've been hired.
Great. And that means it should be signed?
It should be signed, or if you have an emailed version, it's like what I said with the short form word version. If you send them the information about the job and then they reply back, I confirm, or yes, this is correct, that is considered a legal signature. So it's preferable to have it fully executed and signed, but
Mhm.
oftentimes in our fast-paced world, that doesn't work. So.
Right. Totally makes sense. All
Mhm.
right. And another great question here. You mentioned in the opening the distinction between independent contractor and employee, but this contract template only includes a clause for an independent contractor. Is the template still usable if you are actually an employee?
No.
Mhm.
So if you are an employee, then you are covered by the Department of Labor, the employment agreement that you sign, if any, and a whole other set of laws. This is just for independent contractors. So if you are just working independently with your own business, or with your or just separately as a freelancer, that's where this contract would apply. If you are an employee, they're going to have you sign a completely different set of tax forms. You're going to have a different employment agreement, and you will be under a separate set of laws that are enforced by the Department of Labor.
That's right. And it shouldn't go without saying that if you are contracted as an employee with a company, that contract is not eligible for this grant. So this grant applies specifically to freelance dance work. So just want to make that very clear.
That's
All right,
great.
amazing. Jonee, thank you so much. We're gonna, I think, move into closing the session today. Just want to offer so much gratitude to you for all this amazing work that you've done, both developing the contract and offering this webinar today. Thank you.
Absolutely.
Some applause. And we can begin to close out. Thank you all so much for tuning in to Dance.NYC's webinar on the DWR Fund. Any resources shared today will be posted on the program's webpage on Dance.NYC, and our landing page should be currently in the chat. As a reminder, you can schedule a one-on-one legal consultation session with Jonee through the link that is in the chat now. And in addition, we will be hosting another webinar with Jonee on contract clarity on August 12th. And you can register for that webinar via the link in the chat or on our website, and invite your colleagues to come join us in August as well. If you have any follow-up questions or comments, please email us at DWRFund@dance.nyc. And thank you again to our amazing ASL interpreters from SignNexus and our captioning providers from the Viscardi Center. Thank you all. Drink some water. Have a beautiful day.